So good afternoon, everyone. Today we are going to be talking about the benefits of having a Spanish will, why I should have one, how I can mitigate inheritance tax, and all things related to Spanish wills. And I'm joined by my colleagues Patricia and Laura. And although I know them very well, I'm going to ask them to introduce themselves and tell me a bit about their speciality in this area of law. So, Laura, can you introduce yourself, please, and tell us what you do?
Good afternoon, everyone. So I'm a registered lawyer, and I deal with inheritances mainly in the area of Valencian region. Also, we cover any other areas in Spain.
Patricia.
Hi, everyone. So my name is Patricia Rivas. I work for the firm for the last 5 years, and I'm specialized as well in inheritance and trust, wills matters, but especially in the region of Andalusia.
Okay, excellent. And of course, we act for clients inheriting property all over Spain, and what we're going to talk about the general principles will apply to all of those people. So, Patricia, straight into it. Tell me what the benefits of having a Spanish will are.
Well, the benefits of having a Spanish will are different, really. I would like to point out six of them. For me, the most important ones. And the first one will be that it's going to ensure that your assets are going to the people you really want to be the beneficiaries of the same. The second one will be that it's going to make everything easier and quicker in order to administrate your estate in Spain. It's also the third one will be that it's going to avoid unnecessary costs. Obviously, if you have a Spanish will, then it's going to be in Spanish. There are not going to be needed documents from UK or from any other country. No cost for translations. Okay, so all of that. Also, it's going to allow you to mitigate as much taxes as possible. Obviously, if you go to us and you come and ask your dispositions and your wishes, we are going to advise you accordingly in order to mitigate that. Um, the five benefit will be that it can be coordinated with other wills. So you can have a will in UK if you live in UK, or if you are a national in UK, and also in Spain. You can have another in United States if you are from there. Okay, so it can be coordinated with different wills all around the world. And the last one will be that it's going to allow you to choose your national law. So that is an important one because, for example, in Spain, the inheritance law is not too good for some cases. So it's good to know that you can choose your national law if you do a Spanish will.
Okay, that's great. So thanks for those kind of six main reasons to have a Spanish will. And I think we've got to just follow up on those. Everyone wants to pay less tax. We don't say it's tax avoidance, but we can mitigate tax. So, Laura, how might we be able to mitigate inheritance tax for clients?
So it's very important to start mitigating taxes, that you consult, as Patricia was saying, you consult with a specialized lawyer, because depending on each person's situation, it might be advisable to leave it to your spouse only, or to your spouse or children, just to your children, or maybe divide the inheritance into more shares. So it's very important that you seek guidance of a specialized lawyer, and we can provide you with tax advice on your disposition, with the aim of mitigating and reducing inheritance tax as much as possible.
Yeah, and it's a very important point because in Spain, when you leave your assets to family members, they have more allowances than if you leave it to a friend. But not only do people, potential owners of Spanish property or assets in Spain need Spanish tax advice, they may require tax advice to be coordinated between their home country and Spain. So we're obviously happy to speak to your local advisor about how inheritance tax could be mitigated in Spain and also in your home country. Okay, so I've got okay. You've convinced me, Patricia. I need a Spanish will. Laura's told me I can save tax. Everyone wants to save tax. Who can I leave my assets to?
Well, shall I, Laura?
Yes.
Yep.
Well, who I can leave my assets to? It's going to depend really with what law you decide to your inheritance to be ruled, right? If you don't choose any law, then your resident law is going to apply. So we always kind of recommend you to choose your national law. For example, for British people, that is the client that we have the most. They have free disposition if we follow the English law, except for some particular cases. So you can leave your assets to whoever you want if you are British, with these little cases, that particular cases that we will have to study. So that's good, because if you don't choose it, you live in Spain, for example, then the resident law is going to apply. So Spanish law is going to apply, and there are forced heirship. So you have to leave your assets to especially your children.
So, for example, if I, if I've got children and I'm divorced and I've got a new wife, for example, or a new girlfriend, and I wanted to leave assets to my new girlfriend, or then if I hadn't chosen my law, Spanish law would apply, and that means that
If you live in Spain, yes.
2/3 of the assets would have to go to the children.
That's correct.
Okay,
That's
so it's
correct.
important, obviously, to when you prepare the Spanish will to put it to choose your law as well. Okay,
very important. Yeah, it's very important.
And tell me about law about beneficiaries. How important is it to choose them carefully? Bear in mind the tax you talked about.
Yeah, exactly. So depending on the relationship that you have with your beneficiaries, they might be entitled to some deductions and bonifications or not. So it's important to address the residency where you are, or where the house is located in Spain, so that we can advise you on who's the best beneficiary, or what allowances they'll be entitled to. So, for example, in Andalusia, spouses, children, and parents have a reduction of 1 million, and also a bonification of 99%, which means that most likely, unless the property or the assets in total are very high in value, they won't be paying any taxes. Also, the rest of the siblings in Andalusia, they also have a small reduction. This varies from region to region, as we said. And for example, in our region, in Comunidad Valenciana, we have for spouses, children, and grandchildren also a reduction of 100,000 plus 99% bonification.
Okay, so depending on who inherits, they will pay less tax.
And depending where the assets are in Spain. Mm-hmm.
Depending where the assets are located. Okay, that's interesting. So can you give me an example, for example, of taxes? So we've talked about, being married, being not married, choosing your beneficiaries carefully. Patricia, can you give me an example of someone, say, owning a property in Spain with their spouse, and if they died, what tax they would pay?
Well, for example, let's go to like popular case. Okay, imagine that there is a British couple married, having a property of 250,000 euros, equally belonging to them equally. So one of them passed. If they live in Andalusia, and if they have written down a Spanish will, then they are not going to pay anything, because it's less than 1 million. So they don't have to pay inheritance taxes. Okay. But the scenario is going to change a lot if they are not married. That's also another important thing to take into consideration. If you are not married, if you don't have a civil partnership, then consider to get married, or at least to get the civil partnership, which is going to be quicker and cheaper. But it's very important, because if you are not married, or you don't have civil partnership, then it is considered that you are friends. So you will have to pay all the taxes, all the inheritance taxes. There are no allowance or reduction or bonifications.
And do you have? Can you tell me how much that potentially could be for a friend non-spouse?
Around 40% on the amount of the property being inherited.
Wow. So
that's 35,000 for that property. So 250 property shared jointly, it would be around 35K.
So basically, an asset of 125,000 euros, which they're inheriting half of the property, they would pay 35,000 euros. And they've got to pay that within what kind of time scale?
6 months. Then we can always apply for an extension for another 6 months. So in total 1 year, but no more than that. Otherwise, then you will get interest to pay.
Okay. Okay. So it's the same example, or up in the Valencian community where you've got obviously we've got the popular Costa del Sol in Andalusia and the popular Costa Blanca in the Valencian community. What would the tax be for a married couple inheriting a property of 250,000 euros, and then a couple who weren't married inheriting 250,000 euros?
So for the first 100,000, they will be exempt from taxes, and the rest will be taxed, just the 1% left. This means that they might end up paying just maybe 25 euros, which is ridiculous for that price. So it's good, but that's just if they were married, as we were saying. Otherwise, the tax will be the same, around the 35,000, because the tax is regulated in the whole state, and only each region has these specific allowances.
Wow, it's amazing. Okay, any further comments? I mean, for example, if I wanted to sign a will, where could I sign them, Patricia?
Well, we always recommend the clients to sign the Spanish will in Spain, because obviously it's going to be done before a notary public here in Spain. So we can go with them to the notary, which is also good. We can act as a translator, and we are going to help them out with that. But if there is a case that the client cannot come to Spain, they can do it in their country, as long as they meet with all the legal requirements and all the formal requirements of a Spanish will. We can prepare that will, which is going to be in Spanish and also in their language. And it's important that they have to do it before a notary in their country. The problem, let's say, the problem with this second case is that when the will is going to be needed, this is to say in their succession, it's very likely that the notary here, the authorities here, require more documents, additional documentation from their countries. So it's going to make higher the cost. Okay, so that's why we always recommend them to do it in Spain, but it can be also done in their countries or any other country where they are.
Okay. And when I sign a will, who holds on to the original?
In Spain, that's another good reason in order to do it in Spain, is that we have a registry of wills, a central registry of wills in Madrid. So as soon as you sign a Spanish will, the notary is going to notify to the central registry of wills that you have done it. So it's going always to be a record of that. Whereas if you do it in UK or any other country, some of the countries don't have this registry of wills, so the will can be lost or
Okay. Laura, in Commonwealth countries, UK, Canada, America, it's very common to appoint an executor. Would you recommend that an executor is appointed here in a Spanish will?
Not necessarily. So in Spain, the executor called albacea is not needed for Spanish wills. It's optional. But if the will is written clearly, correctly, there will be no need to appoint an executor here.
Okay, so it's maybe good advice to have one, but not essential.
Not essential. And even if there was one named and all the inheritors agreed to get rid of that person, that would be an option too.
Yeah, absolutely. Yeah. Okay, Patricia, let's just say disaster scenario, someone doesn't have a Spanish will. What law would apply when they die?
If you don't have a Spanish will, you are not choosing the law that you want to apply for your succession here in Spain. So it's going to apply your resident law, which is great if you live in UK or any other country where you have free disposition. But again, if you live in Spain, that can be a big problem, because most of your estate is going to go to your children and not to your spouses. So we know sometimes you don't really want maybe your children to have everything, or you want to do other things. So that's why it's very important to have a Spanish will, because you are going to ensure that you are choosing the law that you want to apply. If you don't choose the any law, then it's going to apply your resident law always.
Okay, so wherever you reside. So if you live in
Ex-
Spain, Spanish law would apply. If I lived in the UK and I died without a Spanish will, then UK law applies.
exactly.
Okay, so that's interesting. Okay, and Laura, we talked about executors, and whenever you buy a Spanish property, heirs and beneficiaries tend to need an NI number, which is a Spanish tax number. Would an executor need to have an NI number?
So if there is a UK will or any other country where executors exist and their executors named on it, an NI number would not be necessary as long as the beneficiaries, as I said, are clearly appointed. So the executors would not have to appear at the deed of acceptation of the inheritance, and they won't need NI number.
But Laura, if an executor was, if we were acting for an executor signing an inheritance, would they
Then
need?
yes,
They would then.
yes.
Okay.
Mhm.
So if the beneficiaries are signing the acceptance themselves, then it's not necessary for the executors to have an NI number. But if we're signing on behalf of the executors, as happens quite often, then they would require an NI number. Okay.
Mhm.
Have you got any other comments then?
Not really. Basically, to just advise everyone to have their will drafted as soon as they buy property in Spain, just to avoid everything that we gone through.
Okay, excellent. Okay, well, thank you very much. If you want to contact Laura or Patricia and talk about your wills, you can book a consultation with them on our website or fill out the contact form. Thank you very much.